Legal and Privacy Brief for August 18, 2026. LifeStance Health and Mount Sinai Medical Center reached class action settlements totaling $3.2 million over privacy violations. SafePal, Trezor, and CoinKite hardware wallet breaches expose nearly 40,000 crypto holders to physical threats, while Heights Finance leaks financial data for 750,000 customers. California courts break media advertising models by allowing age discrimination claims under the UNRRA Act, and a federal judge blocks TikTok, YouTube, and Meta from obtaining preliminary injunction against California's SB 976 addictive feeds law. Here's the full breakdown of today's top legal and privacy stories. Next section, enforcement actions. $3.2 million LifeStance Health Group website tracking settlement. LifeStance Health Group agreed to a $3.3 million class action settlement over claims it violated patients' privacy rights by using tracking pixels on its website. The settlement addresses allegations that the mental health services provider improperly shared patient data with third parties through website analytics tools without adequate consent. Compliance action. Healthcare providers should audit all third-party tracking tools, analytics scripts, and marketing pixels on patient-facing websites. Implement explicit consent mechanisms before deploying tracking technologies that may capture protected health information. Review vendor contracts to ensure HIPAA, the Health Insurance Portability and Accountability Act, compliance for all data sharing arrangements. Source: top class actions. $220,000 Mount Sinai Medical Center data breach settlement. Mount Sinai Medical Center of Florida reached a $220,000 class action settlement over a data privacy breach. The settlement provides cash payments and medical data monitoring services to affected patients whose protected health information was compromised. Compliance action. Healthcare organizations should review incident response plans and ensure adequate cybersecurity insurance coverage. Implement multi-factor authentication, regular security audits, and employee training on data handling protocols. Budget for breach notification costs and credit monitoring services as part of risk management planning. Source: top class actions. Next section, litigation updates. Shopify class action survives motion to dismiss. A California federal judge rejected Shopify's bid to dismiss a proposed class action alleging the company secretly collected consumers' personal and payment information through its checkout platform without consent. The court found sufficient allegations that Shopify violated California privacy law by gathering data beyond what was necessary for transaction processing. Compliance action. E-commerce platforms and payment processors should review data collection practices at checkout. Provide clear, conspicuous disclosures about what data is collected, why it's needed, and how it will be used. Limit data collection to what is strictly necessary for transaction completion unless additional consent is obtained. Source: top class actions. Federal court allows California age discrimination claims against tech platforms. A federal district court in San Jose denied preliminary injunctions from Meta, YouTube, and TikTok seeking to block California's SB 976, the Protecting Our Kids from Social Media Addiction Act. The law defines algorithmic recommendation systems as addictive feeds and requires parental consent for minors with default 1-hour daily limits. The court ruled that blocking speech, content moderation, is First Amendment protected, but algorithmic recommendation is not, relying on language from the Supreme Court's Moody v. Net Choice footnote that declined to address the constitutional status of recommendation algorithms. Compliance action. Platforms with algorithmic recommendation systems serving California users must prepare age verification mechanisms and parental consent workflows. Implement default time limits for minor users and provide documentation systems to demonstrate compliance. The Attorney General retains authority to specify age verification methods, requiring flexible technical implementation. Sources: TechDirt. California Appeals Court extends UNRRA Act to media advertising. Another California court followed the Lips v. Facebook precedent, allowing UNRRA Act age discrimination claims to proceed against Google for not serving certain ads to users based on age. The Copia Institute filed an amicus brief, arguing the decision violates First Amendment protections for editorial discretion and Section 230 protections for platform intermediation of third-party content. The decision creates conflict with California laws requiring platforms to restrict certain content based on age. Source: TechDirt. Supreme Court denies Trump rehearing in Carroll case. The Supreme Court denied President Trump's petition for rehearing in Trump v. Carroll, leaving intact a $5 million verdict for sexual assault and defamation. Trump had argued that evidence including testimony from other women and the Access Hollywood tape should have been excluded. A separate petition regarding an $83 million award in a related Carroll case remains pending, raising questions about whether presidential statements constitute protected official acts. Source: Scotto S. blog. Next section, privacy developments. My Doctor healthcare breach exposes 19 million in Poland. Polish authorities are investigating a cyber attack on My Doctor, a healthcare software provider, that potentially exposed data belonging to 19 million people and 12,000 medical facilities. Hackers obtained unauthorized access to historical data through April 2024. Poland's eHealth Center is replacing digital certificates used by medical systems to connect to the P1 nationwide electronic health platform as a precautionary measure, though no evidence suggests the certificates were compromised. Compliance action: healthcare software vendors should conduct immediate security audits of third-party access points and authentication systems, implement certificate rotation policies, and monitor for unauthorized access to historical data archives. Organizations using electronic health record systems should verify that vendors have adequate incident response plans and breach notification procedures. Source: The Record. SafePal crypto wallet breach affects 40,000 customers. SafePal confirmed a data breach affecting 40,000 customers who placed orders between March 2, 2025 and April 11, 2026. Stolen information includes names, email addresses, shipping addresses, phone numbers, and purchase details. The breach resulted from a flaw in an order tracking plugin that allowed unauthorized access to customer order information. This is the third hardware wallet manufacturer breach in the past month, following similar incidents at Trezor and CoinKite. CertiK reports a 33% year-over-year increase in cryptocurrency wrench attacks, violent, in-person robberies, with 52 incidents and $124 million in losses in the first half of 2026. Compliance action: cryptocurrency businesses should implement enhanced physical security guidance for customers whose information has been exposed. Review all third-party plugins and order management systems for access control vulnerabilities. Provide security awareness training to customers about phishing attempts and physical security risks following data exposure. Source: The Record. Heights Finance breach exposes 750,000 financial records. Debt consolidation lender Heights Finance disclosed a May 7 breach of a cloud-based platform that exposed financial information and social security numbers for 734,828 customers. Stolen data includes banking information, account numbers, routing numbers, government ID, social security numbers, tax ID, driver's license numbers, and customer service interaction records. The company operates across 11 states including Alabama, Tennessee, Georgia, Texas, and South Carolina. Compliance action: financial services companies using cloud-based customer data platforms must conduct immediate access audits and implement multi-factor authentication. Review contracts with cloud service providers to ensure adequate security controls and breach notification obligations. Offer identity theft protection and credit monitoring to affected customers. Document all third-party vendor security assessments for regulatory examinations. Source: The Record. Unlimited Technology Systems breach affects 3.8 million patients. More than 3.8 million patients are being notified that their personal and protected health information may have been exposed in a data breach at Unlimited Technology Systems, a healthcare technology provider. Limited details are available about the scope or cause of the breach. Source: Top Class Actions. Flock Safety implements access controls after stalking incidents following a Washington Post report documenting 46 cases of police officers improperly using Flock Safety's license plate camera network to stalk women. CEO Garrett Langley announced new security measures. Changes include recommended 7-day data retention, previously 30 days, new offense filtering, mandatory audit assistance, proactive lockouts, required case codes, and mandatory multi-factor authentication. However, the 7-day retention period is only recommended, not required. Flock's network adds approximately 20 billion license plate images monthly. Compliance action: law enforcement agencies using automated license plate reader systems should implement mandatory audit trails, require case numbers for all searches, and establish independent oversight mechanisms. Review retention policies and consider reducing default retention periods. Implement automated alerts for unusual search patterns that may indicate misuse. Source: TechDirt. Next section, policy changes. White House deputizes private companies for offensive cyber operations. On August 12, 2026, President Trump issued a national security presidential memorandum establishing a program allowing vetted U.S. companies to conduct government-authorized offensive cyber operations against foreign transnational criminal organizations. The program permits two operation types: cyber surveillance operations, covert unauthorized access for intelligence collection, and cyber effects operations, manipulation, disruption, or destruction of information systems. Participating companies must receive written government approval for each operation and act under DOJ, the Department of Justice, and DHS supervision. The memorandum requires compliance with the Computer Fraud and Abuse Act and tracks the CFA exemption for lawfully authorized investigative, protective, or intelligence activity under 18 U.S.C. Section 1030F. DOJ and DHS must establish operating procedures by October 12, 2026. Compliance action. Companies considering participation should evaluate legal risk carefully, as the memorandum does not create explicit CFA exceptions. Consult with legal counsel about liability exposure, insurance coverage for offensive operations, and compliance with international law obligations. Document all government authorizations and maintain detailed operation logs. The program does not authorize general hacking back and requires case-by-case government approval. Source: Debevoise Data Blog. Department of Justice OLC Opinion on Posse Comitatus Act. The DOJ Office of Legal Counsel issued a memorandum stating the Posse Comitatus Act does not prevent military personnel from making arrests near designated national defense areas, such as portions of the U.S.-Mexico border. This represents a significant expansion of permissible military involvement in domestic law enforcement. Source: Lawfare. Next section, Compliance Takeaways. Healthcare website operators audit all tracking pixels, analytics scripts, and third-party tools immediately. The LifeStance settlement demonstrates regulators and plaintiffs are targeting HIPAA-covered entities for unauthorized data sharing through website technologies. Financial services using cloud platforms conduct access control audits and implement multi-factor authentication by September 30, 2026. The Heights Finance breach shows cloud platform vulnerabilities remain a critical risk vector for sensitive financial data. California platforms with recommendation algorithms begin implementing age verification, parental consent workflows, and time limit controls for SB 976 compliance. The federal court's denial of preliminary injunctions signals the law will take effect as written. Law enforcement agencies with ALPR systems establish mandatory audit trails and independent oversight mechanisms immediately. Document all searches with required case codes and implement automated alerts for unusual access patterns following the Flock safety stalking incidents. Companies handling cryptocurrency customer data enhance physical security guidance for customers and prepare incident response plans for wrench attack risks. The 33% increase in violent crypto theft incidents requires heightened security awareness programs. That concludes today's legal and privacy brief. From Carolina Clear Tech, for informational purposes only, not legal advice.